Hey, everybody. Rob Dorr, Vice President of the Minnesota. We have got some exciting news from the Minnesota State Supreme Court, and I will get you updated here briefly. Let some other people filter in. Please do type. Let me know where you're watching from, what app you're watching on. We're multi-streaming to different platforms here, and it's always helpful to know where people are seeing us from. So go drop a comment in, and I will get going shortly. So been quite an interesting wait on this one. We've been waiting over a year for the Supreme Court opinion to come down, and it finally has. So we will get going shortly. We've got nobody important watching from Lakeville. Looks like he's over on X. Good to see you there. Let me know if you can hear me all right too. I'm in the office trying to keep things quieter here. Dawn from Fergus Falls watching on Facebook. Thank you very much, Dawn. Good to see you here as well. I will jump into things here shortly, but been a very long wait on this case from the Minnesota Supreme Court. Over a year we've been waiting for this, and this has to do anybody who owns firearms, particularly if you own a firearm made before 1968, or if you have privately manufactured your firearms, this opinion is going to matter to you. We'll let some more people filter in here across the apps. Only had 2 people check in, so that doesn't give me a lot of hopes here. Do just type in a quick check-in. Let me know where you're watching from, and I would appreciate it. Cass from Texas checking in. Good to see you there as well. Engineered Defense Company in Farmington. Oh, good to see you over on X as well. I appreciate you guys. We will jump into this here shortly. Yeah, been a long wait on this one, and I'll foreshadow it here. A favorable result, not a perfect result, but a favorable result for you peaceable gun owners. Do let me know if you can hear me okay too. I'm not using any external microphones or anything. I wasn't set up for going live. I was doing some other work, and this caught me by surprise, but I wanted to come live and share the news with you guys. So do let me know where you're watching from, and I will get into it here shortly. Anyway, it's been on another matter while we're waiting for people to filter in before I get to the big news. We did just have a hearing last week regarding our lawsuit against the state for the omnibus bill. And we will have some more updates on there soon. We do expect that the district court will issue their ruling. I'm cautiously optimistic that we will get a favorable ruling, at least as far as the issues that we're concerned about. Not overly concerned about, of course, we wanted to take down the whole omnibus bill. That was always a big ask and something that we would like to see done, just given the nature of how it was passed. And then we will we'll take what we can get, but I am cautiously optimistic about a victory as far as our claims there. NASCAR Kelly says she can hear me. That is good to know. And Sarah Walker's mom, she's watching from work, finally stopped crying, and that's good. And I'll let you know shortly whether those are tears of joy or tears of sorrow here. But I appreciate you guys checking in. So what we have here is the Minnesota Supreme Court just issued their opinion in State v. Vagle. And that had to do with a case that was very closely tied to something that we've been working on with Walker Anderson, who is Sarah's son. Who's in the comments right now on Facebook, and it had to do with whether Minnesota's law about the serialization requirement for firearms was constitutional. Now, what happened in State v. Vagle is very similar to what happened with Walker Anderson, is that the state saw a privately manufactured firearm, so a polymer 80 or something along those lines, and decided merely because it didn't have a serial number, it violated this section of Minnesota law. And the section of Minnesota law is not very clear. It's under a section called obliteration of serial number. And basically, it makes it a crime to obliterate a serial number on a firearm or to possess a firearm without a serial number, and then has some references to federal law. Now, what this county of Anoka was arguing, and this is who was prosecuting this, was that any firearm without a serial number was illegal in the state of Minnesota, and that you couldn't possess it. So this would include privately manufactured firearms, so things like your Polymer 80 or anything like that, but it would also include uh, pre 1968 firearms prior to the Gun Control Act of 1968 that did not have a serial number. So the county of Anoka and the state was arguing that uh, any firearm manufactured without a serial number, including firearms that were manufactured before 1968, were illegal in Minnesota to possess. And what's particularly interesting about this, and this was brought up in the case, we brought it up in Walker's case, along with his attorney Blair Nelson. He made this argument that hey, the state itself, the DNR, auctions off firearms without serial numbers. And so this put this into this really weird area where the state's arguing that any firearm without a serial number is illegal, yet you have all of these instances where firearms don't require serial numbers at the federal level that would potentially be illegal, even though the statute's only reference to serial numbers and what a serial number is references the serial numbers. All right, so there's the groundwork. Now, what did the Supreme Court decide? The Supreme Court of Minnesota decided that the law is unconstitutional because it is vague. So that provision means that it is unconstitutional to enforce that provision against people who have privately manufactured firearms. So that means if you've got a privately manufactured firearm, it is legal. You don't have to put a serial number on it, at least under the current regime. Now, what it didn't strike down the whole statute because there are some reasonable interpretations. Now, if you have a firearm that is required to be registered at the federal level, so NFA firearms, so if you're thinking short-barreled shotguns, short-barreled rifles, things like that, machine guns, all of those are still required to be federal registered at the federal level. So if you possess one of those without a serial number, you can be charged under this statute. But what it doesn't apply to, and what the Supreme Court held today, is that it does not apply to firearms that are privately manufactured or before 1968 that aren't required by the federal government to have serial numbers. And Justice Thiessen wrote for the majority, very, very good opinion that basically said it establishes a trap where it tells you have to have a serial number, but then the statute doesn't tell you what the serial number has to be. Now, the Chief Justice Hudson and Justice Procaccini were in dissent in this, and they basically just said, well, hey, the dictionary has a definition of what a serial number is, so we can just apply that. And that just puts you in this really ridiculous standpoint. And Justice Thiessen points this out in his argument that you could literally just take a Sharpie and write number 123 on your firearm and meet the qualifications of the statute. But then he points out that, well, what good does that do if law enforcement finds a statute or a firearm with a serial number 123, put a permanent marker on it? What good does that do? It of course serves no legitimate purpose, and so it just kind of fails just a rational basis review of the statute, of the policy. He also points out that they went and they dug into the historical record when this was debated, and the author of this particular bill was asked, does this apply to pre 1968 firearms that don't require a serial number? And the author of the bill said no. So legislative intent can come in to sort of fill in the gaps about whether or not this was meant to be covered. And so that the Chief Justice and Justice Procaccini's dissent fails on those other points, that you can go with a dictionary definition, but if it falls into a trap that you have no mechanism of complying with it, and then even applying that definition just creates a useless scenario that provides no government purpose, no rational purpose, the statute has to fail. and so it did. Very, very happy. They were tears of joy for Sarah. I'm sure Blair will be moving to have Walker's case dismissed in light of this finding, and it should be done expeditiously. I certainly have some clients here in the office that will benefit from this as well, to when they're just being charged with possessing a homemade firearm. So, what could happen next? So right now, this has been reversed and remanded. Essentially, this charge is going to have to be dropped because there is no way for it to be applied. The Supreme Court's holding is precedential, so that means anybody who has been charged with pending charges or is going to be charged with future charges can't be charged under the statute merely for possessing a firearm without a serial number, as long as it's not an NFA regulated firearm. And then, hopefully that gives some relief. So I'm very happy for Sarah and Walker and their whole family. This has been a long nightmare for them. Walker has family in Canada. He has not even been able to go into Canada because he can't go into Canada with pending felony charges. That's interesting. And I hope that this gets resolved quickly so that Walker can go back to visiting his family in Canada. So very happy for them, and we'll definitely be there along the way to help them. We've been helping out every way that we can with their family. And Sarah, this is really good news, and I'm very happy for you and for everybody who's been wrongfully tangled up by this statute. What else could happen? The legislature could choose to address this. This and try to pass a statute that requires some sort of serialization scheme. I don't see that going very far with the current legislative makeup, but it is an election year, and I guess it'll be an election year next cycle with that, and a new legislature could always try to pick this up. We will be fighting any attempts at this. I'm sure the attempts will come. I'm sure that your typical band of suspects are drafting legislation right now to try to fix this loophole that they're going to call it. We will be there every step of the way to fight it, and I don't see it having much of a chance, but you never know. It's a very slim majority. All they need is to peel off a couple of people. Republicans who are soft on gun rights, or any of those types of people, to get this through. You never know what's going to happen there. And then, I think there was one other question that popped up: is what does this have to do with the Court of Appeals opinion the other day that had to deal with the constitutionality of this? Not much, really. So the Supreme Court of Minnesota specifically punted on the constitutionality question. They really narrowly focused in on the serial number provision and whether that is enforceable, or whether it's void for vagueness. And they found that it's void for vagueness as applied to these types of firearms. Now, the other opinion held that the entirety of the statute was constitutional. There was a Bruin challenge to that statute. They held that was constitutional. Now, that being said, I don't think it's particularly constitutional. There's nothing in the history of the United States that required firearms at the time of the founding or at the time of the 14th Amendment, required firearms to be serialized. So I think there is still a viable challenge, and this could go up to the Supreme Court on those grounds. But the Court of Appeals just held the statute as constitutional. What the Supreme Court of Minnesota did in this case and said that it is not constitutional because of vagueness when applied to privately manufactured firearms and firearms manufactured before 1968. There's a little bit of a difference there as far as the angle of which these cases were attacked. So this one doesn't have much of an interference on the other one, other than the fact that the individual who was charged in that case that did go before the Court of Appeals might have actually grounds to have that charge expunged, which might give him some standing issues if he was to try to challenge it to the Supreme Court of Minnesota. But we will cross that bridge when we get there. That is being handled by the appellate public defender's office, and I have offered my support on that case moving forward. The one that just went before the Court of Appeals, the Jones, I think it is, and we will see when we get there. Feel free to drop any questions that you guys have. I haven't seen any comments or any chats here for a little bit, so I don't know if my chats are not showing up, or if you guys are just staying quiet and taking in the good news. Let me see what we've got here. Yeah, I don't see any new comments or anything. So if you do have any questions about this opinion, I'll hang out for a little bit, but I just wanted to give you guys the breaking news of this opinion. Once again, for those just tuning in, the Minnesota Supreme Court just released an opinion after 1 year of waiting in State v. Vagle, which held that the restrictions on the prohibition on possessing a firearm without a serial number in Minnesota are unconstitutional when they're applied to privately manufactured firearms and firearms manufactured before 1968. So that means that if you own a firearm that is not a NFA required firearm, so if somebody has a privately manufactured firearm that's a fully automatic, that would not be covered by this, because that means that it is still required to be registered by the federal government and therefore subject to this statute. But if it is not a firearm that is regulated by the NFA, so short-barreled rifle, short-barrel shotgun, machine guns, things like that, then it does not need to be serialized in Minnesota. Now, if you remove a serial number, if you obliterate it, if you alter it, you can be charged under the statute. This only applies ostensibly to people who privately manufacture lawful firearms that are not required to be registered by the NFA, people who own firearms manufactured before 1968 that don't have a serial number, family heirlooms, and things like that. You're good to go. You cannot be charged under the statute. So very, very good news. Exciting to hear. I'll hang out just about 2 more minutes here. I see a few people are taking in the good news. Cass has a question. Is there a maximum amount of time they have to release the decision, or can they sit on it for years? So the Court of Appeals has a very brief window that they have to release an opinion. The Supreme Court has no such restrictions. So they could literally sit on it as long as they want. They can sit on it as long as they want, and they don't have to release an opinion. So it has been over a year on this one. There's really nothing that anybody can do to force them to enter an opinion. So I hope that answers your question, Cass. Engineered Defense Company says that his grandpa's 1937 Winchester is safe. That is good to hear. Yes, it would have been a shame to have to be forced to deface such a beautiful piece of history with some ugly serial number. That would have been good. Gus Pollock, the good news is that the Supreme Court just released their opinion in State v. Vagle, saying that applying the state statute about requiring serialization of firearms to non-NFA items is unconstitutional. So if you own a privately manufactured firearm that does not require NFA registration, so think short-barreled shotgun, short-barreled rifles, machine guns, and it is, or if it's a pre-1968 firearm that doesn't have a serial number, you can own it lawfully, you can possess it lawfully, you can carry it lawfully. The statute does not apply. Now, these do take time. This does take time to filter down to different law enforcement agencies and things like that. Our previous recommendation in this was for you to either bury it somewhere, keep it out of state, whatever, or serialize the firearm just to that you individually don't get caught up in this. But now you can go and recover those firearms from the bottom of whatever lake they were at. You can go get them out of that safe deposit box in Wisconsin. You can build them if you want. They are perfectly legal here in the state of Minnesota. Now, again, as I was saying, this does take time to filter down. Not every law enforcement officer keeps up with breaking Supreme Court news. So if you do, get seen carrying one of these, that you still could face the possibility of arrest. You should be a quick turnaround and release, but don't expect every law enforcement officer in the state to know what you guys know now, because they're probably not watching this live stream and aren't keeping up on the latest breaking news. But this is big news. Everybody, I'm very glad for Sarah Fogris and Walker Anderson. They are they have been dealing with this for a couple years now, and it has been a long slog. And very thankful that Walker's long state-induced nightmare is over. and that the Supreme Court, very surprisingly, and Justice Thiessen asked some very tough questions during the oral arguments, and he really dug in on this issue. And I was expecting that he was going to not go along with the regime. The majority of the court agreed with him. Very very disturbing dissent from the Chief Justice Hudson and Justice Procaccini, who think that if you can just substitute vagueness with no actual path to compliance with a dictionary definition. So let's just say that we took that argument, that you take the dictionary definition of serial number and apply it. You don't need the federal definition of a serial number. You still need to know, how can you lawfully get a serial number on that? So if you have a firearm without a serial number, you bring it to the gun shop, you've now transported an illegal firearm in violation of Minnesota statute. There's no amnesty in there for getting it serialized. There's no thing saying, if you serialize it yourself, here's where the serial number has to be. It has to be etched in. It can't be drawn on. It has to be etched in X amount deep. All of these things that were left completely vague, the Chief Justice and Justice Procaccini were perfectly content just leaving in there, leaving law-abiding gun owners hanging in the wind, because they didn't etch in or take a Sharpie and write 1, 2, 3 on their firearm, which served no legitimate government interest whatsoever. No rational basis to have a firearm number that you manufactured yourself, that you etched in a serial number to. Like, what good does that do if that gun gets used in a crime? They're not going to be able to trace it back and say, oh yep, that gun was manufactured by John Smith out in his garage. It made no sense. The dissent made no sense, and it's very very disheartening. But Justice Thiessen wrote a really really excellent opinion, did a deep dive, and just applied just kind of the common sense lens to it. And I did like that he pointed out and provided screenshots too in the opinion that even the DNR has been selling firearms without a serial number that they've confiscated. So if you're going to hold law-abiding Minnesotans accountable, then you better hold the DNR accountable for trafficking in illegal firearms. So I did Sarah said that he called the AG's office to ask how to serialize a firearm, and they probably told you that they couldn't provide legal advice, right? They told you to pound sand. I'm sure the answer was, we can't provide legal advice, which is kind of laughable, because they had provided no guidance. If only Paul Morades were still in business. There's others out there. You strike one down, 3 more take its place. Right, Mead Monkey? All right, guys, I don't see any other questions there. I'm going to get back to work here, but I really appreciate you guys. Thank you guys for tuning in. Do me a favor here, but in our last minute or two down here, just write a comment in on whatever platform that you're on. That's going to help boost exposure and get this out there. And then please, please, please share this video to all of your groups, to retweet it or re-exit, repost it, whatever they call it. Share it to your gun clubs, to your different groups that you're on Facebook. Help us get this out there. We know that we're being suppressed on different platforms, so you sharing it yourself helps us break through that and get out to more eyes for people who need to hear this good news. So that's it for me. If you guys could do all of that, I would greatly appreciate it. But thank you guys again for tuning in. We will keep you guys updated on our lawsuit against the state right now for the omnibus bill. We expect something to happen soon, and then there's always stuff in the pipeline. So stay tuned. And if you appreciate the work that we do, please do consider a membership donation. All of that helps us keep the wheels going here and keeps the ink in the lawsuit printer fully stocked, so that we can keep suing the government when they're infringing on your rights.